Hello everybody, welcome back to the channel, to the Butterfly Monkey channel. Today will be part 3 on citizenship. This will also be my last video that I will be doing on citizenship. Apparently it hurts too many people's feelings on what I am saying and what the principles of law are saying about citizenship. Not only about the 14th Amendment, but before the 14th Amendment. All right. I'm going to start right here. This is a manual of elementary law by Fishbeck, which I shared in my Telegram, and it's also one of the PDFs that I was reading in the first video I made on elementary law based on citizenship. I'm only going to read this section 20 right here. And then I'm going to continue with Hooven versus Allison, right? The terminology used here. The terminology used here in Belmonte versus the immigration. This is a 1998 case. And then I'm going to break down Downs versus Binwell. I'm not going to read the whole cases or all these cases. I'm going to read the pertinent parts that apply to the context for each court case. And then lastly will be this last court case from 1862, which was prior to the 14th Amendment by like 4 years and 2 years before the Civil Rights Act was passed. And these will be key to understanding how everyone is a U.S. citizen who is either born or naturalized here and is also a state citizen. So to start, it says citizenship is the state of being vested with the rights and privileges of a citizen. In this country, there are two kinds of citizenship and allegiance, one national and the other state. It is for Congress to determine who shall enjoy the privileges of national citizenship within the limits prescribed by the Constitution. This book was about 20 years after the 14th Amendment came out, 22 years or something. And the laws of the several states fix the conditions under which state citizenship is acquired. No state can make or enforce a law which shall abridge the privileges and immunities of citizens of the United States, nor can any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of laws. And you know this just from reading the 14th Amendment or case law or any analysis of the 14th Amendment. This is a provision of the Constitution of the United States, and any state law to the contrary is void. It is further provided in the Constitution that the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. The right of a citizen to expatriate himself from and become a subject of another nation was questioned in such country until Congress passed a law recognizing the right. What I want to emphasize here is this. This statement right here, what he's stating, shows for sure that there's two types of citizenships here, right? Aside from what they said above, right? But it's also stating that you need to be a state citizen to have all the rights and privileges of a citizen of the several states as it is described in Article 4 of the Constitution. This is important because essentially a citizen of the several states in Article 4 is a national citizenship, but it is not exclusively the United States citizen in this context. I need you guys to understand that first. You have state citizen, and then you have a citizen of the several states. And you have to be a state citizen to be entitled to those privileges and immunities that you find in Article 4. Okay? That's one. This right here is Hooven versus Allison. For those of you who don't know, this is a case about importing goods from a foreign source, right? Which the taxation of which is a power that Congress has, right? This case dealt with Ohio trying to tax the same batch of goods after it has been hit with an importation tax by the federal government, right? And this should be a famous case that everyone should know simply because of this. The term United States may be used in one of several senses. A may be merely the name of a sovereign occupying the position analogous to that of sovereign nations in a family of nations. This term right here is the American Empire. It may designate the territory over which the sovereignty of the United States extends. This right here is federal jurisdiction, the second one. Or it may be the collective name of the states which are united by and under the Constitution. And of course, that is the several states of the Union. Right? The key here for this case, without reading it to you, right, is that the determination of the word United States here meant the several states of the Union. Right? They brought up how they defined it by how they excluded the territories. That the term United States was only meant to mean the several states of the Union, meaning when foreign goods entered any of the borders of any of the several states. It had nothing to do with the territory. In this case, the territory at the time was the Philippines. The Philippines was not considered a foreign country. It was considered a territory. But nonetheless, the territory or a foreign country and importing goods from it is an outside source from the borders of the Union. That is key here to understand on why the term United States for the tax provisions for importing goods, right? The defining term United States means the Union States. That's key here. That's what they decided in this case, and they use court cases like Downs versus Bidwell and so forth like that. All right? This is important to understand from this case right here. The next case, this is going to be a short video. The next case, right, is going to be Belmonte, right? In Belmonte, this is about a person who was born in the 1930s in the Philippines during the time when the Philippines was a territory. Okay? She was claiming that, hey, the territorial law, like they did of the common law that Britain applies to their laws, made her an automatically citizen of the United States, regardless if it was a territory or not a territory, like a state of the Union. Right? The court determined in this case that no, it does not. We did not incorporate in our laws that principle that Britain has used. Our defining term for United States, right, means the several states of the Union. Right? And they break this down and they tell you why. So I'm going to read this part. The principal issue in this petition is the territorial scope of the term, the United States, in the Citizenship Clause of the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof. Right? So this term right here, subject to the jurisdiction thereof, has been defined by the courts to mean any one of the jurisdictions of any state of the Union. It does not mean the government per se. Right? The court case, I think, is Kim Wong Ark or Wong Kim Ark or whatever it's called. You guys should know that case. So, and I'm not going to read that now, but that's where you'll find that aspect. I might take a screenshot of it out of my phone and put it in the Telegram, but that's how you know that that's what that means. Right? Subject to the jurisdiction thereof. Right? It's a plural. It's not singular. Are citizens of the United States and of the state wherein they reside. petitioner who was born in the Philippines in 1934 during the status of the United States territory, argues she was born in the United States and is therefore a United States citizen. Right? Petitioner's argument is relatively novel, having been addressed previously. So this is a 1998 case. This case, that the first time ever that it was addressed from a person from a territory claiming to be U.S. citizen, was in 1992. And that's this case, Rabang versus the Immigration Service. No court has addressed whether persons born in a United States territory are born in the United States within the meaning of the 14th Amendment. And of course, certiorari denied, right? So that person lost. Okay? In a split decision, the Ninth Circuit held that birth in the Philippines during the territorial period does not constitute birth in the United States under the Citizenship Clause of the 14th Amendment, and thus does not give rise to the United States citizenship. Right? So in that case, they're flat out saying that your birth in a territory that is a part of the American Empire does not constitute that territory as one of the states of the Union under the 14th Amendment. Right? And they'll tell you why. For the purpose of deciding this petition, we addressed only the territorial scope of the phrase, the United States, in the Citizenship Clause. We do not consider the distinct issue of whether citizenship is a fundamental right that extends by its own force to the inhabitants of the Philippines under the doctrine of territorial incorporation. Doubtless Congress, in legislating for the territories, would be subject to those fundamental limitations in favor of personal rights, which is really fundamental rights in this context, which are formulated in the Constitution and its amendments. We note that the territorial scope of the phrase, the United States, is a distinct inquiry from whether a constitutional provision should extend to a territory. They're citing Downs versus Bidwell. And this is an insular possession case that everyone should be familiar with. The phrase, the United States, is an express territorial limitation on the scope of the Citizenship Clause, because we determined that the phrase, the United States, did not include the Philippines during its status as a United States territory. We need not determine the application of the Citizenship Clause to the Philippines under the doctrine of territorial incorporation. Arguing that the 14th Amendment may be applied. So this judge, he dissented, right? Judge Brennan in 1990. He dissented that there should be, he had Fourth Amendment cause. Because the Fourth Amendment applies to the land or something like that. But specific provision doesn't. Specific provision that use the words. Right? Despite the novelty of petitioner's argument, the Supreme Court in the insular cases provides authoritative guidance on the territorial scope of this term United States in the 14th Amendment. The insular cases were a series of Supreme Court cases that addressed challenges to duties on goods, so the tax on imports, transported from Puerto Rico to the continental United States. So that's the insular ones was based on Puerto Rico. The Hooven case was based on for the Philippines. Like this case, it's from the Philippines. Puerto Rico, like the Philippines, had been recently ceded to the United States. The court considered the territorial scope of the term, the United States, in the Constitution, and held that this term, as used in the Uniformity Clause of the Constitution, was territorially limited to the states of the Union. So this is the scope of the term United States for the import tax, right? All duties, imposts, and excises shall be uniform throughout the United States. See Downs versus Bidwell. It can nowhere be inferred that the territories were considered a part of the United States. The Constitution was created by the people of the United States as a union of states to be governed solely by representatives of the states. In short, the Constitution deals with states, their people, and their representatives. Puerto Rico was merely a territory, appendant, I can't really pronounce this word, appurtenant, and belonging to the United States, but not a part of the United States within the revenue clauses of the Constitution, right? So this is all part of the revenue clauses of it, right? They broke it down that the United States only means the Union States under Downs versus Bidwell, and as we just seen, Hooven used the same terminology. Right. The court's conclusion in Downs was derived in part by analyzing the territorial scope of the 13th and 14th Amendments. The 13th Amendment prohibits slavery and involuntary servitude within the United States, or, keyword or, any place subject to their jurisdiction. Right? They use the word there. The 14th Amendment states persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The disjunctive or in the 13th Amendment demonstrates that there may be places within the jurisdiction of the United States that are no part of the Union to which the 13th Amendment would apply. What they're saying here, they're saying the term United States means the American Empire, that slavery has been banned both in the Union States and in all territories. That's how they broke down this word United States for the 13th Amendment. And if you read the court cases, especially Downs Bidwell for sure, but what is it, the Sal versus Bidwell, right? What is it? The Lima versus Bidwell. If you read this case too, they go into the court cases that will complement Downs versus Bidwell. That's why they say in part analyzing the territorial scope. That the conclusion was in part, right? Citizenship under the 14th Amendment, however, is not extended to persons born in any place subject to the United States jurisdiction. So they're saying the 14th Amendment does not extend to persons born in any place. That means it doesn't apply to persons born on territories, but is limited to persons born or naturalized in the states of the Union. In dealing with foreign sovereignties, the term United States has a broader meaning than when used in the Constitution, and includes all territories subject to the jurisdiction of the federal government wherever located. So in dealing with sovereignties. Following the decisions in the insular cases, the Supreme Court confirmed that the Philippines, during its status as a United States territory, was not a part of the United States. And that's the Hooven-Allison case that we just went through, right? Where they gave the three different terms of the United States, and depending on the context, will give you which definition that they're using. As we have seen, the Philippines are not part of the United States in the sense that they are subject to and enjoy the benefits and protection of the Constitution, as do the states which are united by and under it. Philippines are territories belonging to, but not part of, the Union States under the Constitution, and therefore imports brought from the Philippines into the United States are brought from territory, which is not part of the United States, into the territory of the United States, right? So it's important here what I just read here and how they came to this conclusion, along with the court cases and the history of what has been decided literally from day one. One of the older cases is 1830, this one right here. Inglass versus Trustees of Sailors, Snug Harbor. This is an 1830 case. You're talking about 35 years, 36 years before the 14th Amendment was passed. And one of the cases that I'm going to go through, right, is going to be 2 years before. Let me see if I should keep continuing. All right, this is right here. Accordingly, this is for all those who believe that they're nationals, and especially the ones that believe that they are nationals according to Title 8. Right? The Supreme Court has observed that without deciding that persons born in the Philippines prior to its independence in 1946 are not citizens of the United States, and they give you another case, stating that although the inhabitants of the Philippines during the territorial period were nationals of the United States, they were not United States citizens. The inhabitants of the islands acquired by the United States during the late war with Spain, not being citizens of the United States, do not possess right of free entry into the United States. This right here should blow everybody out the water on that concept of nationals. And I'm going to further that. So that's the end of this part. So up here, right here, let's see if I'm going to read this whole thing. Yeah, I'm going to read this whole thing right here. In 1902, after a period of military rule in the Philippines, the United States Congress enacted the Philippine Government Act, establishing the terms of the United States civil rule of the Philippines. The Philippine Government Act provided that all inhabitants of the Philippines as of April 1899 who had not elected to preserve their allegiance to Spain would be deemed and held to be citizens of the Philippine Islands, and as such entitled to the protection of the United States. So what did they just tell these people? Either you're going to show your intention that you're reserving your Spanish citizenship, right, or get out, right? Or and then you're, if not, then you're one of us. Whatever citizenship the Philippine Island has, and then whatever protection the United States gives them. In this case, it's going to be the term called national. The Philippine Government Act did not make the inhabitants of the Philippines citizens of the United States, but conferred on them a status properly referred to as nationals. And they give you a citation here. C4, Charles Gordon, Immigration Law and Procedure. The term national referred to non-citizen inhabitants of territories that the United States had acquired outside of its continental limits. Continental is the physical borders of the Union of the States, the Union States, who nevertheless owed permanent allegiance to the United States and who were entitled to United States protection. So that's a national. And that's literally the definition that you find in 8 USC 1101-21 or something like that. 1101-A-21 or 22. The status was a convenient construct for those who favored, meaning Congress, territorial expansion, but did not wish to make the people of the new territory citizens of the United States or otherwise suggest that they might aspire to equality under the American constitutional system. So even those who believe that they're nationals, what did they just say? You don't have the equality of the American constitutional system. And they give you Jose A. Cabranes, Citizenship and the American Empire. Notes on the legislative history of the United States of Puerto Ricans. Notably, under the Philippine Act, the Philippines were specifically excluded from Section 1891 of the revised statutes, which provided that the Constitution and all laws of the United States shall have the same force and effect within all the organized territories, and in every territory hereafter organized as elsewhere within the United States. So they're saying elsewhere within the United States. They're talking about territories, right? But they told them what? They were specifically excluded from this. That means the Constitution did not apply. The laws of the United States did not apply like they do. Like if you guys read the Act of 1871, right? February 21st, which incorporated the District of Columbia, right? Okay, well, that right there, they incorporated this. This is why the Constitution and the laws of the United States apply to that territory. But my point in reading this is this. They give you the annotation right here. The term national of the United States is presently defined as one who is a citizen of the United States or a person who, not a citizen of the United States, owes permanent allegiance to the United States. And they give you the section in the Act, which is 101A22, and then they give you, of course, Title 8, 1101A22. This through the door should blow you out the water that you are not a national in this context. Through the door. There shouldn't be no argument, no debate, no nothing for whoever listened to this video this far. Okay. Next case. Downs versus Bidwell. And all I'm doing here is repeating what Belmonte already said. Right? It has, in short, the Constitution deals with states, their people, and their representatives. The 13th Amendment to the Constitution prohibiting slavery and involuntary servitude within the United States or in any place subject to their jurisdiction as a collective, and as a collective is the government, right, is also significant as showing that there may be places within the jurisdiction of the United States, meaning the American Empire, that are no part of the Union, meaning the 50 states. As of today, the 50 states, right? To say that the phraseology of this amendment was due to the fact that it was intended to prohibit slavery in the seceded states under a possible interpretation that those states were no longer a part of the Union is to confess the very point in the issue, since it involves an admission that if the states were not part of the Union, they were still subject to the jurisdiction of the United States. Upon the other hand, the 14th Amendment, upon the subject of citizenship, declares that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside. Here is a limitation to persons born or naturalized in the United States, which is not extended to persons born in any place subject to their jurisdiction. It's restricted. And for those who believe the word persons right here for the 14th Amendment means some corporation or something, it does not. It cannot. Any and every principle of law for citizenship going back hundreds of years, all of it applies to natural people, men or women. It does not incorporate for any corporation. And if there's plenty of court cases that flat out say it. A corporation is not a citizen under the privileges and immunities clauses under Article 4, and is not a corporation under the 14th Amendment, the citizenship provisions. Plenty of court cases for that. Anyone who's reading a analysis of the Constitution by the Supreme Court justices will find this to be true. The question of the legal relations between the states and the newly acquired territories first became the subject of public discussion in connection with the purchase of Louisiana in 1803. This purchase arose primarily to the fixed policy of Spain to exclude all foreign commerce from Mississippi. This restriction became intolerable to a large number. All right, and that's not going to go. So that's the portion I want to read this. And again, Downs versus Bidwell dealt with importing goods from Puerto Rico. Right? But nonetheless, they broke down these terminologies in these amendments in this court case. So next is this case. I can't pronounce this guy's name. It's Inri and Weihiltz. I'm going to say the W is V, right? So Weihiltz. The portion I'm going to read starts on page 477. It's only a 14-page document, which is in my Telegram group. It says, this doctrine has been recently very clearly stated by the Supreme Court of the United States in the Dred Scott case, in which the question was whether a Negro could be a citizen of a state within the meaning of the Constitution of the United States, so as to be entitled to sue in the federal courts. That court said. So first, they're debating if he can be a state citizen, and because the Constitution affords, what do you call it? You have to be a state citizen to be afforded the citizenship of the several states. Those are two different meanings, right? In discussing this question, we must not confound the rights of citizenship, which a state may confer within its own limits, so that's one, and the rights of citizenship as a member of the Union. So they ain't calling a U.S. citizen or nothing here yet. But they did tell you two things here. And as we already know, a member of the Union, right, is a citizen of the several states as defined, and the privileges and immunities defined in Article 4. They continue, says, it does not by any means follow, because he has all the rights and privileges of a citizen of a state, that he must be a citizen of the United States. So at this time, this is 2 years before even the Civil Rights Act was passed, and like 4 years before the 14th Amendment was passed. Sorry. At the time when Dred Scott, which is, I think, 8 years before, I can't recall the case, I think it's the 1850s. He's saying that just because you become a citizen of a state at this time, that automatically you do not get the privileges of a citizen of the several states. Right? It says it does not by any means follow, because he has all the rights and privileges of citizen of a state, that he must be a citizen of the United States. He may have all the rights and privileges of a citizen of a state and yet not be entitled to the rights and privileges of a citizen of any other state, meaning the rights and privileges of the several states of the Union. Right? The citizenship, the portion in Article 4. For previous to the adoption of the Constitution of the United States, every state had an undoubted right to confer on whomever it pleased the character of citizenship. This is them, each state, having that power. And they still have this power to this day, which we're all going to learn on what's going to happen with all the illegal immigrants. We're all going to learn this. And to endow him with all its rights. But this character, of course, was confined to the boundaries of the state and gave him no rights or privileges in other states beyond those secured to him by the law of nations and the comity of states. Nor have the several states surrendered the power of conferring these rights and the privileges by adopting the Constitution of the United States. Each state may still confer them upon an alien. Now the question is, could they do it to an illegal alien? The reason why is because Congress has that power to have them, to be naturalized and all that stuff. Or any one it thinks proper, or upon any class or description of persons. Yet he would not be a citizen in the sense in which that word is used in the Constitution, meaning Article 4, nor entitled to sue as such in one of its courts, nor to the privileges and immunities of a citizen in other states. This right here, he's describing a citizen of the several states of the Union, the Article 4 stuff. But he's saying that just because the state gave them the state citizenship stuff doesn't automatically give them the other. At this time, it doesn't. At this time is when the Dred Scott case was decided. Let's look this up. I know it's... I want the case. So 1856. That's when the case... So in 1856 was when he was making that. At that time, you do not get both automatically. The rights which he would acquire would be restricted to the state which gave them. The Constitution has conferred on Congress the right to establish a uniform rule of naturalization, and this right is evidently exclusive and has always been held by this court to be so. Consequently, no state since the adoption of the Constitution can, by naturalizing an alien, invest him with the rights and privileges secured to a state under the federal government. So they're right here, secured to a citizen of the several states of the Union, because they're calling it under the federal government, right? Although so far as the state alone was concerned, he would undoubtedly be entitled to the rights of a citizen and clothed with all the rights and immunities which the Constitution and laws of the state attach to that character, meaning only in that state. The 14th Amendment changed this. The 14th Amendment conferred that you being born in a state of the Union, you automatically get the national citizenship also, meaning you get the privileges and immunities of a citizen of the several states of the Union, and is it how it's described in Article 4. And of course, now it's called a U.S. citizen. You get all the privileges and immunities of what's called the United States citizen. Both of those are national in character and distinct and separate from a state citizen. You have to understand that they're separate. The thing is, though, a United States citizen stands on its own, meaning that a citizen of the United States that is domiciled in Puerto Rico, he does not have the privileges and immunities of a citizen of the several states of the Union. Why? The reason why is because he is not a state citizen. Puerto Rico is not a state. So he only gets the United States citizenship attributes. He does not get the other national attributes, which are called a citizen of the several states of the Union. For you to get that under the 14th Amendment, you need to be a state citizen too. And the only way to be that is to be born in one of the states of the Union or be naturalized in one of the states of the Union. I hope that is clear right there, because I can't make that any more clearer. The power of a state to confer a right of citizenship so far as it alone is concerned, and which does not amount to a full citizenship of the United States, could not be more plainly stated than it is in the above extract. So he's stating it can't be more plainly stated than what we just read right now. At this time, during the Dred Scott case, you do not get both automatically. You need to subscribe to Congress to become a United States citizen, or take part in it to retain those attributes of a citizen of the several states of the Union. It wasn't automatic yet. It is true, however, that further on in the opinion on page 422, so he's still talking about Dred Scott here. So too, a person may be entitled to vote by the law of a state who is not a citizen, even of the state itself. And in some of the states of the Union, foreigners not naturalized are allowed to vote. And the only reason why this happens is because the specific state is allowing it. They have enacted laws to allow it to happen, that have nothing to do with the federal government and any characteristic of the national citizenship, because they prescribe the rules for it. And the state may give the right to free Negroes and mulattoes, but that does not make them citizens of the state, and still less of the United States. This is all dependent if the state gives this, right? He's saying the state may give the free Negroes or mulattoes, right, the right to vote. I'm assuming, right, the right, because it doesn't say what right. So I'm gonna go off the last sentence, right? Give the right to vote to free Negroes or mulattoes, but that does not make them citizens of the state. It's a franchise. It's an elective franchise. You don't have to vote. Voting is not a dependency on citizenship, right? And still less of the United States. Still, what is here said does not detract at all from the broad doctrine stated in the former extract, so above. It means no more than this, that the state may confer the right to vote without necessarily making those on whom it is conferred citizens of the state even. This may possibly be true, but the power of the state being conceded to confer the rights of citizenship within itself upon whomever it pleases, the question whether it has done so or not is a mere question of intention, meaning intention of the legislator of that state, to be determined by the proper construction of its own constitution and laws. And of course, in Dred Scott, if you've read it, he was denied citizenship in that state simply because the Constitution says it citizenship belonged to white men. Not even women, but white men. So he was following the letter of the law. No feelings or anything like that as how wrong slavery and all that stuff might be, right? I'm just saying he followed the letter of the law. And one who also which the supreme tribunal of each state is to determine for itself. This being so, although it may be possible for the state to confer the right of voting on certain persons without making them citizens, yet I should think it would require very strong evidence to the contrary intention, to overcome the inference of an intention to create citizenship when the right of suffrage is conferred. The remarks of Justice Curtis in his dissenting opinion in the Dred Scott states the true effect which ought to be given to the existence of this right. He says, but further, though as I shall presently more fully state, I do not think the enjoyment of the elective franchise essential to citizenship. He's saying it's not essential to citizenship. There can be no doubt it is one of the chiefest attributes of citizenships under the American Constitution, and the just and constitutional possession of this right is decisive evidence of citizenship. So it's prima facie evidence, right? Well, not prima facie because it's saying decisive, so I'm wrong on that. The provisions made by the Constitution on this subject must therefore be looked to as bearing directly upon the question, what persons are citizens under that Constitution? So in that case, Dred Scott specifically, white men. Indeed, it is often used in a general sense as meaning only permanent resident. That is one of the definitions given by Webster. So in Field, another court case, it was held that a resident alien who had not declared his intentions and was entitled to no political rights under the laws of the state was still a citizen within the meaning of the attachment laws of the state against absconding citizens. So he didn't even have intention, right? Was not declared his intentions and was entitled no political rights, was still a citizen. Yet it is true that in a political sense, the word citizen implies the possession of political rights. But the rights of voting and holding office are always given as the most complete and perfect attributes of citizenship. Thus, Webster gives the following definition. In the United States, a person native or naturalized who has the privilege of exercising the elective franchise or the qualifications which enable him to vote for rulers and to purchase and hold real estate. So that's that definition. Bouvier's definition is as follows. One who, under the Constitution of the laws of the United States, has a right to vote for representatives in Congress and other public officers, and who is qualified to fill offices in the gift of the people. Let's see if I should continue here. Bearing in mind that the inquiry relates only to such rights of citizenship as this state could confer, right? Because they didn't have power to confer national citizenship. That has always been a power of Congress with respect to itself alone. How should it be determined upon the Constitution with respect to a class of persons to which the petitioner in this case belongs? The answer must be that there is no room for doubt that it was the intention to confer upon such persons, as far as it is possible for the state to do so, the full rights of citizenship. Okay, this case, I forgot to state in the beginning, he's from Eastern Europe or something, right? And he has been in this country for a while. And he has declared his intention to become a U.S. citizen. He's white. And he wanted to do service in the military, in the militia. The court denied him, and this is his appeal. But because he showed intention to stay, intention to domicile in the state, and all that, those show that he met those requirements for citizenship, at least within the state. For those purposes, to be included in the militia. Again, the context is citizenship to be part of the militia. In the first place, those persons had an equal voice with any other citizens in establishing the Constitution itself. By Section 9, Article 14, they were authorized to vote upon its adoption or rejection. By the Article of Suffrage, they were made qualified electors and are eligible to all offices except as governor, lieutenant governor, or judges. So this right here, by the rules of the state, the Constitution and its laws, this guy, he cannot be governor. He cannot be lieutenant governor or a judge. Just like in the U.S. Constitution, what does it say a foreigner cannot be? That naturalized here. Can't be president, can't be vice president, and I think you cannot be Supreme Court. I'm not sure about that one though. I forgot. I'll let you guys decide if you guys want to read the rest. Right there, whenever the full right of citizenship of the United States is intended, it is so expressed as in respect to the office of governor, lieutenant, or judge. It is provided that no person shall be eligible who is not a citizen of the United States. So it has to be both. that state citizen also has to have U.S. citizenship status to become the lieutenant governor or whatever. And the only way to do that is by being a natural born, because they take it away through the door on naturalized citizens. And that's it. That's all I got. And this will be the last video, the third one, right? If you're still in doubt of it, then so be it. The only thing I could tell you is this. As a state citizen, being born or naturalized here, you have the rights and privileges and immunities under Article 4, how it's been described for that class of persons. But you will also have, because that's a national characteristic, right? But you will also have what they then later created, and that's the U.S. citizenship. And the rights and privileges for that. But the concept is, and the difference is, that you could be a U.S. citizen without being a state citizen. You can't be the other way around. There's nothing that states that shows that. But a U.S. citizen, if he's not a citizen of a state, then he doesn't get state citizenship protections, rights and privileges and immunities. He doesn't get the rights, privileges, immunities, and protections as a citizen of the several states of the Union either. Because his local law is that of Puerto Rico, Samoa, or some other territory. That's the best way I could describe it right there. These concepts here are a birthright to natural persons. It has nothing to do with corporations. And that's all I got. And if you still don't agree with it, so be it, man. At least make it known. Give me references. Give me information that makes you believe otherwise. I don't want opinions and theories that don't mean nothing to me without facts, without things provided for it. And no doubt, at the very least, no doubt you're not a national as described in Article 8 or in Title 22. Right? Sorry, in Title 22, a U.S. non-citizen national. In Title 22 for passports, U.S. national means a U.S. citizen, and it means a U.S. non-citizen national, right? But like I said, that encompasses two of them. A U.S. non-citizen national is just a national. So, to each their own, and good luck. This will be the final video, and probably the last real conversation I'm going to have about this. I'm going to just go back to trust law and something else. But I will be doing other videos on elementary law. All right? Have a good one, guys. And please like, subscribe, something. Make me want to continue doing these. Right? So, enjoy, and welcome to the Butterfly Monkey channel. Sorry for the laugh, but hey, it's funny sometimes.